a trip to Canada, but you're worried about a past DUI? You're not alone. Canada takes criminal history very seriously. Even a single DUI can affect your entry. Today, we're going to break down the difference between having just one DUI on your record versus having multiple convictions on your record and how Canada is going to evaluate that. My name's Christine Jurusik, and I'm a partner here at Richards & Jurusik Immigration Law, and I've been helping people enter Canada with convictions since around 2008, since we really started sharing information with Canada, and U.S. citizens' records became known to Canada and Canadian border officers. So let's start with a single DUI. In Canada, a DUI is considered a serious criminal offense. It's equivalent to impaired driving under Canadian law. A DUI compares to impaired driving. And even one conviction for a DUI or impaired driving or OVI or OWI or DWAI can make you criminally inadmissible to Canada, even permanently, meaning you're going to be denied entry at the border when you show up. So here's the good news. If your offense is old enough and enough time has passed since the completion of your sentence, which is typically 10 years, you might be considered what's called deemed rehabilitated. That means Canada may overlook that one offense without requiring a formal application for you. Now, if it hasn't been that long, or if your offense happened more recently than December 2018, when they changed the law in Canada, you still have options. You can apply for criminal rehabilitation or a temporary resident permit to go, but you may not be eligible for that automatic deemed rehabilitation, even if you just have one offense. So now how does that compare to someone with multiple DUI convictions versus one DUI, or if you have maybe one DUI, but a mix of other offenses on your record as well? That's a different story. With more than one conviction on your record, you're not going to be eligible for deemed rehabilitation, unfortunately. Even if 100 years passes, you're never going to automatically be forgiven. And Canada is going to view your record as a pattern of behavior more than just a one-time mistake. And that's why you're going to need to make an application to go. So in this case, where you have multiple convictions or more than one DUI, your main pathway is going to be applying for criminal rehabilitation, which requires, number one, for at least 5 years to have passed since the completion of your last sentence, and strong evidence that your lifestyle has changed since then. Approval is not guaranteed, and the process can take a year or more, so you want to plan early before your next trip to Canada. How is Canada going to evaluate that? So I've helped people all the way from having one minor conviction to, felony convictions and a whole history. Now, the number of offenses matters, but it also matters the amount of time that's passed since then, the severity of the offenses under Canadian law, and that's not just under American law, that's under Canadian law, so you need to make that analysis. And then evidence that the rehabilitation has taken place so that your life has changed since these offenses happened. That's really what they're looking at in order to make a determination for this. They're not just checking a box, they're really assessing the risk and responsibility to the Canadian public of allowing you to enter Canada. Now, one DUI doesn't automatically mean no, so that's good, but multiple convictions can then make things more complicated. So if you're planning your next trip, it's best to check your eligibility to go with a legal professional before you make that plan. And remember, when in doubt, just give us a call. It can save you time and stress. Safe travels, and we hope to see you in Canada.